we are going to sharing some issues, some topic about will writing, what you should know. So before that, may I just do a simple and quick survey? Anybody of you know about what is will? And do you have a will?
Oh, yes, Mr.
Maybe
Gan.
you can just give me a reaction saying that, okay, whoever have a will, maybe can give me a thumbs up or whatever. Emoji, emotion, okay, few of yous. Okay, so, okay, then one more thing, everybody know what is will, right? Informal, okay, informal will letter. I will go back to this. What's mean informal letter? Okay, so everybody know what is will, right? Basically, you have some basic knowledge about will, no better from the kopitiam chit chat, from some drama series or movie. Actually, we know more or less we know about wills lah. Okay, we maybe heard about that, but we're not really well informed about what is will. So today I'm going to share with you this guy, okay, regarding this will. Okay, I'm sharing my slide. Okay, actually today when I have this topic, I'm thinking what am I going to share with you all? Is this just share with you about what is will and how to write a will? But I'm thinking for Malaysia, everybody will feel like, hey, I want to know what is will, and I want to know how to write a will. But for me, I mean, from a perspective, from a point of view of a lawyer, merely know about what is will and how to write a will is not enough. So I will add up what you should know, because today I'm going to share with you regarding the whole estate planning in Malaysia. That means what will happen to your estate if somebody pass away. Okay, so we have to know about the applicable law in Malaysia. And at the end of the part, I will just share with you some will writing cases that handled by me, or some probate and LA issue that handled by me before. And maybe from all this story, you will know that actually how you are going to enhance or how you are going to amend your will so that will suit to your requirement or suit to your needs. Okay, so just before that, just for your information, today my sharing will be just for the just for your knowledge sharing purpose. So it not considered as a legal view, legal advice or whatever. So it's just for sharing purpose, and I hope that all this information won't be circular out. Okay, so hope you understand about this lah. Okay, actually, this is not the first time I talk about this issue, and I conducted few sharing section for this issue before, and the reason why I start the sharing of this issue is because some of my clients actually when they come to me, I just notice actually they have a lot of estate planning issue not yet dissolved after 20 years. So when take for example, actually the starting is one of my teacher. When she come to me, she said that her grandmother have left out an estate and durian estates, and still under her grandmother name, but not yet been transferred, and it's already 20 years ago. So when I noticed actually a lot of issues come out, because when I want to do the transfer of the name to her name and her mother name, I noticed there are a lot of party involved. And theoretically we can do it, but practically it's already out of my control and out of my knowledge to settle, because it involve a lot of the relative. It may involve about 20 to 30 people. So very hard to continue. And another story is about the picture that I show now. Actually, this is a lot of sad story, okay, come to us. Some of the children or whoever, they maybe just grab for the so-called estate. Okay, you will see the wording. This called 遗产, actually is an estate lah, for the deceased. So this is a sad story that we always heard from our friends or relative. So this is the reason why I want to share about this. When we talk about will writing, we are not only focusing on the how to write a will. Actually, today I want to share with you about these three parts. Firstly, I will just share with you regarding the related laws and the procedure applicable in Malaysia. Okay, for this estate planning issue, because I notice a lot of people, they may not have a correct knowledge or the right knowledge about all these related law and procedure. And the second part, I will just share with you regarding the estate distribution, because a lot of people will come out with a question, hey, whether this estate belong to my father, whether my uncle and auntie can and are entitled to that or not. So I will answer to this question later. And the last part, I will talk about will and trust writing. Okay, so first of all, I will go to the related laws and procedures first. Okay, you always, I will ask this question first. Okay, to administer, the administration of an estate, do you think it is automatically? Okay, take for example, let's say I have a joint, I'm the joint owner of my son for a house. So the house is under my name and my son's name. So one day, if I pass away, whether the house will automatically belong to my son, how do you think? Anybody can give me a response. Maybe you can have a chat box there. If you think that is automatically, you can put 1. If you think not, it will be 2. Okay, some of them feel not, some of them say yes if the spouse has passed away. Okay, okay. Okay, most of us are saying no. Then how about second scenario? I have a joint account, bank account with my wife. Let's say I pass away, my wife can take out all the money, and the money in the joint account is belong to my wife or not? When I talk it automatically, if you think yes, my wife can get all the money, you can put 1. If you think not, it will be 2. Okay, somebody say have to wait for 6 to 12 months. Somebody will feel that it's 1. Okay, I will say, firstly, we have to clear our mind, like what you all just now answer. Actually, administration of an estate is not automatically. All of us, we will know when a person passes away, all his property, no matter is movable, which is a bank account, or immovable, which is a house or land, or maybe short lot, will be frozen. We will say it's frozen. That means nobody can go to touch it. It will maintain status quo. We will say maintain in status quo. Okay, so for the house just now I mentioned, it will still remain under my name and my son's name. Okay, so it will be frozen. But for the house, normally people may not realize about the frozen state, because let's say this house, okay, currently me and my son are staying there. So when I pass away, actually nobody will come to interface the ownership of the house. My house, or maybe my son or his family may continue to stay in the house without any obstacle, right? So you will feel like the property seems like belong to my son. Okay, but it will come up a problem when my son want to sort it out, because when you want to sell a property, you need the owner to sign the so-called sell and purchase agreement. But my name is still there, so I already passed away. So nobody can sign the sell and purchase agreement, and the process, the transaction will be stuck there. Only that time people will start to question, how come the house been frozen already? Okay, second scenario will more obvious when the joint name account. And actually for joint account, answer your question just now, actually, it will also be frozen. Movable or immovable property will be frozen. So even the account is under joint name, and you will ask, no, my account, we will put that either one side can get the money. But just for your information, once the bank have a knowledge about one of the person already passed away, they will just freeze the account. So nobody else can take out the money from that account. So that means if I have a joint account with my wife, after I pass away, my wife even cannot touch single cent from that joint account. Okay, that will be a problem. Okay, it have to take a process, we so-called unfreeze, which is the legal knowledge, and which the legal process. Okay, that I will mention after that. So this is one of the news that always come to us. The freeze on joint account burdens living partner, because nowadays most of our savings actually is in the bank, savings account, current account, whatever. So if let's say it's under a joint name, it will be in freeze, in frozen. So nobody can take out the money. It is under the law, actually. We cannot just take out the money from there. Okay, so please bear in mind, all these estate or this property, they won't transfer to the other person automatically. We have to at least do something. So people will think, the account will be transferred. Then you will be surprised, we got 40 million unclaimed cash and assets. But I'm not saying that 40 millions all belong to the joint account, whoever one of the holder already passed away, but part of them will be there because the survivor, they may not aware about the account and they will just leave it the account to become the unclaimed cash and assets. Some of my clients, even I obtain a probate or letter of administration for them. After 2 years, they will come back to me. They say, hey, Gan, suddenly I receive a letter from this Jabatan accountant. They say, hey, my wife or my husband have this amount of unclaimed money. It may be few hundred, up to maybe 10, 20,000 or more on that. So quite a number of these unclaimed cash and assets, which is in the bank account. Okay, so basically, if we talk about court procedures, okay, when somebody passes away, you have to bear in mind, we have to do something. Now, first step, we already clear. We have to do something to unfreeze the property, no matter it's movable or immovable. But how to do it? Normally, first question we will ask whether the deceased have will or without will. So this will be the procedure that we will go through. Let's say we start from the right hand side with wills. If somebody pass away with the wills, so this process will be relatively more simple. Okay, we just have to get a original of the will and also a death certificate. Then the lawyer will just help the executor who have been nominated in the wills. We will go to apply for the grant of probate. We call it GP. When I say probate, actually it's because this is a court order issued to the executor. Okay, and appoint this executor to administer, okay, to just settle with all the property, okay, to admin the property. So the distribution of the estate will be by the executor. So executor with the GP will go to do the distribution of the estate. Okay, let's say somebody passed away without the wills. Okay, or actually there is a will, but the executor nominated in the wills passed away already. So that means there is no executor. Then we will go to the other process, which is so-called letter of administration process, called LA. Okay, in short form, we call LA. So first, we have to, among all the beneficiary, which is stated in the Distribution Act. Okay, among them, we will appoint one administrator. And the rest of the beneficiary will just sign a letter of renunciation as an administrator. And we have to get two sureties, which is a guarantor. These two sureties, they have to guarantee that the administrator will distribute the estate according to the law, and they won't misuse their power. Okay, so later on, the lawyer will go to the court, apply for a letter of administration, which is so-called LA. And after that, we will do the distribution of the estate by the administrator. This will be the court process. So everything will be done by your lawyer. I mean, the lawyer will go to the court to apply. Okay, this will be the first. So just, I mean, in summary, you will see the difference with will and without will. Okay, with will, the order will be grant or probate. Without will, we call it LA. So the person who execute the will, who distribute the asset will be called executor under the will. If without will, that person we call it administrator. In Malay, we call it pentabe. Executor, we call it wasi. Okay, then for wills, we no need to get any sureties. But for the LA application, we need to. But sometimes we can apply to the court to exempt this requirement. Okay, if let's say it's a simple case, it's just a small family member or that, then we can just apply for this exemption. And the distribution will follow the will. So whatever estate, okay, we will just follow the testator, who is the deceased intention, how to going to distribute. Then for the distribution, without the will, we will follow the Distribution Act. And how will be the distribution rate? I will mention about this after this. Okay, so this is go to the court to so-called unfreeze the estate. If you don't want to go to the court and the deceased pass away without will, okay, then we can go for these two. Either one, you can go to the Amanah Raya, because Amanah Raya, they have a power to get a LA, okay, from the courts to distribute to administration, to do the administration, okay, for the property does not exceed 600,000. Okay, so we will know that Amanah Raya, beside the right will, actually they have a trust administration power. They also have the estate administration power. This is so-called Amanah Raya Berhad. If you don't want to go for Amanah Raya, nowadays a lot of people, they don't go for court, they don't go for Amanah Raya, they go by themselves, go to the land office. Under this law, Small Estate Distribution Act 1955. Okay, as long as the deceased, okay, have one of the immovable property, at least one, okay, if more than one, never mind, it's just a total of the property, total of the estate below 2 million, then we can apply to the district land office for a letter of administration. Okay, but please bear in mind, if you have a will, the only way you go to unfreeze will be go to the High Court. Okay, you cannot go to the land office, because currently I just handle one case. I also don't know what happened. Before that, based on the other legal advice, this client go to the land office to apply for LA. Even her father already have a will. So, I mean, on the halfway, the land office kick out the case and refer back to the Shah Alam High Court. Shah Alam High Court come out a letter and ask them to proceed and continue this matter in the High Court. Okay, apply for the grant of probate. So halfway they come to me and I continue from there. So please, if you have a will, the only way is go to the High Court, not go for land office. It will wasting your time. Okay, so this is regarding the related laws and procedures. It's quite technical, but no worry. You just have to bear in mind there is no so-called automatic distribution. You have to do something. Anything happen, okay? In short, you can refer to a lawyer. Okay, ask them whether you go for the court or go to the land office. They will advise you properly, or just advise you what is the next step. Okay, just don't leave the estate like that and hope that it will automatically transfer to your name or to your children's name. It won't happen. Okay, so do something. Second, I will talk about this estate distribution. Okay, this one will be very simple. We just have the two parts. You have to bear in mind, if somebody pass away with a will, so all the distribution will follow the will. That means whoever entitled to what portion of the estate, actually, we will just do it according to the will. So the deceased, they can decide, okay, who will be the beneficiary, how much of the portion he can get, okay, from the estate. But if let's say somebody passed away without any will, then we will follow the Distribution Act 1958. Okay, so now I will just go with you for this Distribution Act 1958, because a lot of people sometimes they have a question. Okay, because will, for those cases with will, very simple. Without will, will a little bit complicated. We will go for this. Okay, just now, at the beginning, I talked about whether my uncle, auntie entitled to my parents' estate or not. Okay, for this, we have to bear in mind, under Distribution Act, they just categorize few beneficiary to different level. Okay, first we are talking about the first level. This first level, okay, consisting by 3 group of people. One is the spouse. It means it's either the wife or the husband. Second will be the issues, means the children. Third will be the parents, the deceased parents, father and mother. So these 3 group of people will become the first level of the beneficiary. As long as any one of them still surviving after the deceased pass away, they mean the second level, third level beneficiary, they will not come into picture. So whether the uncle, auntie come into the first level, the answer is no. As long as the deceased spouse or any of the issues or any of the parents still surviving, so-called uncle, auntie, sibling, they are not come into pictures. Okay, we have to know about the distribution rate for all this. Okay, if let's say only the spouse survive, yeah, definitely the spouse will get 100%. If only the issues survive, they will get 100%. But if let's say more than one issue, so more than one children, so they will distribute in equal share. Okay, no matter it's male or female, girl or boy. Okay, it will just distribute in an equal portion. Okay, then parents also, if let's say got 2 parents survive, then they will just distribute 50%, 50%. If only one parent, let's say it's father or mother, survive, then he or she will get 100%. Okay, then the second scenario will be like that. One of the group is not, it's not surviving. Let's say parents, okay, let's say when you pass away, your parents is not there, only left out the spouse and the children. So the spouse will get 1/3, but the children will get 2/3. But it will distribute in equal share among all the issues. Okay, same thing if let's say somebody pass away, the spouse already passed away before him or before her. So the children and the parents were entitled to that. The parents will get 1/3 and the children will get 2/3. Okay, let's say somebody passed away, somebody single, right? Okay, not single, without children. Okay, already married but without children. So the spouse and the parents are surviving. So the spouse will get half. The parents will get half. The parents will share among them. Let's say if father and mother is still surviving, so father and mother will get 1/4 each. Okay, let's say somebody passed away, the spouse, the children, the parents are there. So the issue, which is the children, will get half. Okay, 50%. Then the spouse will get 1/4 and the parents will share among them for 1/4. Okay, this is an issue. So you will know about how we are going to distribute. Okay, if there is a money, then we just do a simple calculation, a mathematical calculation. Okay, if let's say there is a house land left out, then we will put the share. So if let's say the house is 100%, so we will just according to this calculation, I will take the last example. Let's say there is a property, there is a house left out. So the spouse will get 1/4 of the share of the house. Let's say only one children left, that should one child left, then the child will get 1/2, half share of the property. the parents, let's say both parents surviving, then they will get 1/8 share in the property. So the property will be joint name under the spouse name, the child name, and the two parents' name. Okay. If let's say this first level, spouse, the issues, the parents are not surviving, surviving before after the decease, then the second level, third level will come out. This will be the second, third, until the seventh level of this distribution act. First will be brother and sister. So all the sibling they entitled to the estate in equal share. If let's say no sibling left, no sibling surviving, then grandparents will come into picture. If there is no grandparents, uncle and auntie will come into picture. Okay, let's say no uncle and auntie, great grandparents. After great grandparents will be great grand uncle and great grand aunties. Let's say somebody passed away without all these relatives, only until that stage government will come into picture. Okay, so government is the last party entitled to somebody estates. Okay, until now, I think, okay, everybody clear about all this, huh? The law applicable under the estate distribution. Okay, so far this is all about the law. Then the last part I will discuss about today's issue is actually regarding the will and trust. Okay, this is so-called the tools used by most of the people currently to distribute their property. Okay, when you ask me what is will, I will just define the will as this. Actually, it's a legal document that we set forth our wishes, okay, regarding the distribution of our property, and also to mention about the care of any minor children. This is the purpose of a will. Okay, so when the will will enforce, whether it needs been stamping or not, okay, a will no need to be stamped. You no need go to do adjudication or go to the inland revenue to put a stamp, 10 ringgit and go to chop. No need. You just have to keep it, okay, sign, put a date and keep it properly. It will be enforceable upon the testator who is doing the will passing away. So as long as you are still alive, the will are not enforceable, and you are entitled to change your will anytime, whenever you need it, you feel like you want. I will discuss about this rewrite of will at later stage. So to prepare a will, normally, okay, we will see this. What is the contents of a will? If you want to write a will, okay, this will be the process. But before that, I will just answer just now about the informal will. I'm not very sure about, just now somebody mentioned about informal will, how you're going to define informal will. Later, maybe we will discuss about this. But some of my clients, they will say informal will is the will prepared by myself, without going through any will writing company, without going through any lawyer. So they so-called informal will. Actually, I did come across some informal will. This is my definition for the informal will. If this is not the scenario that who are just now in the chat box, somebody mentioned about that, maybe you can elaborate later. So for me, as long as the will is in written form, it should be okay. And you follow the formality of a valid will, it should be all right. It's not necessary to be prepared by a will writing company or prepared by a lawyer. Okay, because for a will to become valid, you have to be signed properly, have two witnesses, follow the format, the existing format, then should be all right. And very clear about all the intention of the testator and talking about the distribution of the will and enforceable. Then this will, I will say, is a valid will. Okay, so to make a valid will, we have to know about some contents first. Okay, first, you have to name executor, at least one, maximum 4 executor. In Malay, we call wasi. Okay, you will see the term we use lah, wasi. Okay, for my suggestions, please nominate at least about two to three executor, because 4 executor is too many for me. For one is not so secure because your executor may pass away before you. So we will put 2 executor. One is as a main executor, another one will be the subsidiary or the substitute executor. And second, if you have any minor children or disabled children, you have to name 2 guardians. Okay. If there is no 2 guardians, the court will help you to nominate. Okay, they have to take care about the minor and the disabled. Okay, that you have to talk about beneficiary. Who will be the beneficiary in your wills? Then you will ask me, who are entitled to be a beneficiary? I will tell you anybody. Okay, it can be your children, it can be your spouse, it can be your parents, it can be your friends, your uncle, your auntie, and in some of the Western countries, they even would name their pets as the beneficiary. Okay, nowadays also a lot of people, they would name the beneficiary, they would name who? Some NGO, some charity organization or some company to be their beneficiary. It is enforceable. You can write into the wills. Okay, you have to think about it. Who will be entitled to distribute to get portion of your estate? It will be the beneficiary. And third, we can put some condition for distributing. Okay, especially for those children. Okay, under the law, only the person who age 18 years old and above are entitled to distribute or entitled to the portion of the estate. But anyhow, you can put a further condition. Let's say you are thinking, my children 18 years old is still too young. You can put 21 years. It should be okay. You can put 25 years. You even can put a condition they must get married before they are entitled to the distribution of the estate. Okay, all this you can put as long as it's still legal and enforceable. Okay, then some of the people, they will put religious issue. As long as my children, they must be a Christian, must be a Buddhist before they entitled to my estate. It should be okay. Okay, it's up to you. So will, you can write anything as long as it is enforceable and legal. Okay, so and other thing you can put in the will. You can put your hobbies, or maybe what you are going to distribute your property. Maybe you can put some condition, ask your executor to donate part of your estate to anybody or to help anyone. Okay, so the second will be this one, estate. What property or what estate you are going to put into your will? Okay, we will go through one by one. Okay, as long as, please remember, as long as the transfer of the ownership for that property involve third party, involve the relevant authority, you must put into your wills. Okay, as long as the transfer of ownership, okay, involve relevant authority. Let's say first, the immovable property means the land. So if you want to transfer the ownership of a land, of a house, you involve the land office. So you need third party, you need the relevant authority to register your transfer. So you have to put in the will, so that lawyer can apply a grant of probate for you. Okay, so immovable property, you have to put in the list of the estate in the will. Second, the share. Those whoever you maybe you purchase via the OSK Hong Leong Bank investment or whatever, the shares. So we have to put in the will. And also the cash savings, fixed deposit in the bank. It will be part of your estate. And the fourth also vehicle, motor, car. But for me, bicycle, you no need to put in because ownership of bicycle there is no registration with the relevant authority. So if you don't want to put into estate, don't want to put into the will, it doesn't matter. Okay, jewelry also, because jewelry, we no need, it doesn't involve any registration, right? You just give to the children or maybe spouse or that. So it can, or if you don't want to put in, I don't see any problem. Okay, but the last two, okay, this EPF, do you think EPF want to put in the will? Normally, I will advise my client, hey, no, you no need to put into the will, because for this KLBSB or EPF, we can do a nomination with the EPF board. So you just nominate somebody else, anybody become your so-called beneficiary for the EPF fund. So you no need to put into the will. And also for the insurance, if you purchase insurance, you will nominate somebody as the beneficiary, right? So you no need to put into the will. Okay, so this is the list of the estate. And then for writing a will, other methods will be like that. People will always ask me, for will, something we have to think about that. Is the will is a secret or not? Okay, because people will feel, hey, this will, I heard that it should be P&C. I should keep it as a secret to anybody. For me, please don't do like that. Yeah, will is a P&C. Nobody will go to show their will to everybody. But you don't keep it as a secret. You have to let your children or your beneficiary, or at least your executor, know about there is a will. It doesn't mean you have to disclose all the term and condition in the will, but you have to let your family know that you actually did do a will. And maybe you keep with the will company, or where you keep this will, you have to let your family member to know about that. And also, if there is a weakness, please make sure the weakness cannot be the beneficiary. It will make the beneficiary entitlement become null and void. So let's say you put your elder son as one of the beneficiary. You don't ask your elder sons become your witness or his wife, okay? Because it will make that the portion that you give to your elder son become null and void. Okay, so people will feel like, hey, I will just ask my son to be my witness. No, it cannot be like that, like this way. So please, take note about this. And where to keep your will? Okay, just keep somewhere in your house lah. Okay, so normally in our house we have somewhere that we put some important document. You just put together. Okay, if you put in the safety box, please make sure that there is a third party know about the password. If not, then it will be a problem. Without a will, we can only go to apply for a letter of administration. And if we go to the LA, that means all your estate will be distributed according to the Distribution Act and not according to your will. So your will become a wastage in this case. Okay, and please remember, there's only one will anytime. Please don't prepare one will for your property A, another will for your property B. Okay, it doesn't work. You have to put all your property in only one will. But you can rewrite your will anytime. You can always override the previous will and have a new will. Okay, so when you want to rewrite your will, you can do it anytime, but certain scenario, I will recommend you to do this, especially this one, change of the marital status. Okay, once you married, all the will you done before, you prepare before, will be void. So if you are single, you do a will now, but if you marriage, the will be cancelled automatically. But if you divorce, okay, it won't affect your will. The validity of the will is still there. Please pay in mind. But if you remarriage, the will become void. Okay. And if there is a executor or beneficiary passing away, then I will suggest you to rewrite your will, okay, to reflect the current scenario. Or there is a new family member, maybe a new child, born, then maybe you want to amend your will, or maybe there is a significant change of the assets. It may be a increase or decrease of your assets, or anytime you want to rewrite because you feel like I don't want to give to this beneficiary, I want to change, then you can always rewrite the will. Okay, so this is regarding the will. And the last part I will touch is about the trust. Okay, so I think nowadays people also heard about trust. Okay, a lot of will writing company, they also have this kind of service to prepare a trust. So normally what property we can put in the trust? First, your cash or your property, the house, the land, or some of your insurance, we can put into the trust. Not everything can put in the trust. Nowadays, I don't see people will put their vehicle or their jewelry or their share into a trust deed. This will be the three main trust deed that we have, cash, property, or the insurance. Okay, so we as the owner of the property or the cash or the insurance, we are called settlor. Okay, we are put our assets to the trustee. Okay, we put our property to the trustee, and this trustee will distribute, okay, to the beneficiary according to the trust deed we prepare. This is how the trust works. So to create a trust with a trust deed, normally we will entrust our cash, our property, or our insurance to the trustee. Okay. So this will be the thing that we were putting in now. Okay. So to prepare a trust, normally this one is more technical. I wouldn't recommend you prepare the trust by yourself. It is not like a will. Will you can always prepare by yourself as long as you follow the formats. Okay, but for a trust, you need to appoint a trustee, which is a trustee in Malaysia. A lot of trustee company, like what we familiar is like Rockville, some of the RHB trustee or some public bank trustee, or that they have this trustee service. So you have to appoint them as a trustee. Then they will prepare a trust deed for you according to your needs, your intention. Then they will manage your trust property, either it's cash property or the insurance, and they will distribute the trust property when you pass away, or maybe you are in the scenario that you are in coma or whatever. So actually trust, when the trust can be enforced, it not necessary upon the passing away. Some of the trust we can put that, okay, I can make the trust trustee to enforce the trust when the settlor is in coma, maybe in coma for more than 14 days, or in a scenario that he or she cannot take care of herself. Then the trustee will come into picture, or upon the passing away. Okay, you can put the condition to trigger the trust. Okay, to trigger the trustee to do something. Okay, so this will be the process. And for a trust, this is the reason why people will do it. Because first, if you think that you want to protect it from the creditor claims, because technically, in legal wise, when you entrust your property or your cash or your insurance to the trustee, that property or that cash or insurance, it doesn't belong to you anymore. It belongs to the trustee for and on behalf of the beneficiary. Okay, it will be distributed, or it will be administered according to the trust deed. It's not according to you. So it will be protected from the creditor claim. If let's say you are in bankrupt, then this property, it won't be affected. Okay, then it is not part of the estate. You cannot put the property or the cash into your wills anymore. Anything have to follow the trust deed. This trust deed will override the will. Okay, and the protection of the beneficiary, especially for the minor and disabled. Okay, because somebody, they will set up a trust fund. They will put a trust fund. how am I going to doing to protect the minor and disabled? This will be the scenario. Maybe I can suggest to you all. Some of them, they will just purchase insurance, maybe a life insurance. So if let's say something happened, or 1 million will be paid out from the insurance company. So we will put this 1 million into the trust fund. So my trustee, in the trust deed, I will mention my trustee have to manage this trust fund, okay, by giving to my minor or my disabled children, okay, every month, maybe 2,000. So every year, every month, they will just pay out from there, okay, to the children or to the minor or disabled. But the trustee, they will charge you some administration fee. Definitely, you can check with them how much they are going to charge. But definitely, they will just manage your fund according to the trusted. So this is the way that people use to protect their minor and disabled. Okay, this is about the trust. Okay, basically my sharing about all the will and trust is until now, it's come to the end. So until now, you should be covered about, just now I mentioned about the 3 parts. Okay, first is regarding the related law and procedure. Second, regarding the distribution of the estate, and third, regarding the will and the trust. So I hope all this sharing can let you have a good picture about how you're going to manage your estate. Okay, if let's say somebody passed away already. So I hope my sharing can let you have a better knowledge about our Malaysian law regarding this issue.